Welcome to the source of commercial real estate, where we talk to the experts in non-residential commercial real estate so you can grow your business, find a competitive advantage, and use real estate to live the life that you want. I am your host, Jonathan Hayek, and today I am talking with Preston Brooks with Cox, Castle, and Nicholson. Preston, I am sincerely looking forward to learning from you today and hearing your expertise. How are you doing today?
Doing great, Jonathan. I appreciate you having me on.
Preston, why don't we get started by you telling us about your background, how you got started in the field that you're in, and what you spend your time doing today.
Sure. Well, I'll take you back to the beginning. I came out of law school, and I was what we call a judicial law clerk, meaning I became an employee of the federal government for a year and clerked for a federal judge here in Los Angeles. And it was a great experience. It was chock full of different kinds of cases. So the neat thing about the job, or one of the many neat things about that job, is the ability to try a number of different areas, to do some deep research into different areas, and to see lawyers practicing before the judge in court on a number of different substantive areas. And I would say at the end of that year, I learned that I was probably not slated to be a litigator, even though I like to joke, Jonathan, that I do litigate during real estate downturns. But I also learned that environmental law was an area that kind of piqued my interest. So after that 1 year stint ended, I went to Latham and Watkins and eventually joined their environmental department. And that was really good training ground. Learned a lot while I was there, met some really good people, and worked side by side with some really quality lawyers. But they tend to represent, big business, not so much real estate interests. And so as a result, you tend to be representing the polluters. And what I started to gravitate towards was this idea of brownfield redevelopment, sort of the intersection between real estate and environmental law. So that's what then attracted me to Cox Castle, where I've been really for the last, hate to say it, 30 years.
So, Preston, you're an environmental lawyer, and you're specializing in redeveloping these plots. You used the term brownfields. So can you talk a little bit about what a brownfield is? And yeah, let's start there. What is a brownfield when we're talking about that?
Sure. Yeah. Let's get into our terms. So the EPA has a particular meaning when they use the term brownfield. It's basically any site that the redevelopment of which will complicate or be complicated by the presence of hazardous substances or pollutants. And they actually call it the actual or perceived presence of hazardous substances, because sometimes you don't know, but you might know the background of a site, and it could be one that's concerning and will require some due diligence and investigation before you'd want to buy it and develop it. So really, brownfield is a dirty site or a potentially dirty site that's going to make your goal of seeing some new, higher and better use of property be complicated by the presence of it.
So a lot of investors and developers might be more familiar with a phase one environmental study. Would a brownfield present itself during a phase one? Would a brownfield be noted before a phase one is completed? Or how does a phase one environmental study fit into the idea of a brownfield?
Yeah, that's a great question, because phase one serve a couple of different purposes, right? It's often a gating document. They're relatively inexpensive for most developers to to utilize. And it's a relatively quick and cheap way to do a little sleuthing using environmental professionals. They are looking for clues, both physically, if you will, as they scour a property and they go to the site to look for clues. But also they have access to databases of lots of different governmental agencies' files that would indicate to them whether there's a need to go on to what's called a phase two, where you're doing something more invasive. A phase one, you're not poking holes in the ground. You're just looking for those clues, and at the end of the process, the consultant would come up with a recommendation about whether to go a step further. And it could be doing a phase two. It could be something else, like additional areas of research, like looking at surrounding sites to see if maybe they have caused some adverse impact to the subject property.
And so, if an area is identified as a brownfield, does that mean these phase one and phase twos have been completed, or is there another process that has gone on that's identified this area as a brownfield?
The thing about environmental due diligence in the commercial real estate world is it's an iterative process, right? So you could keep going and going and going with multiple successive phase twos, depending on what is found. You know, I just had a phone call this morning with a client who's struggling with exactly that. There's a strategy call. If you are looking at a brownfield site, do you do what I call Swiss cheesing the property, where you have one shot, you go in, you collect samples from all media, like soil vapor, groundwater, and to all depths that the contaminant might occur, and laterally, what's your coverage? Or do you go in and do this on a more piecemeal basis? Certainly, the full and extensive approach is going to be very expensive often, and maybe not justified. And part of my job is looking at the scope of work that a environmental consultant would recommend and seeing if it is either under adequate, it's not adequate enough, or if it is overstated for what the risk is, and maybe it's better to take it piecemeal to save expense and time, and maybe you get enough information to know whether to proceed.
Let's get into risks and liabilities for developers and investors looking at projects and properties with potential contamination. So first, actually, why don't I ask you, with what sorts of contaminants are we talking about when we're talking about a brownfield?
So the stuff you'll see over and over and over again are PCE and TCE. They are found in very common solvents that were used for industrial purposes for decades in California and elsewhere. And also, PCE is the contaminant or product that was used as dry cleaning in the dry cleaning industry for many, many years until recently. So those are the primary ones. And of course, there's also all of the constituents of petroleum from leaking gas stations and the like. And there's others. I would say your primary culprits that we come across on a more routine basis are dry cleaners, gas stations, but also just general manufacturing uses. And the heavier the manufacturing was, the more likely that there were issues, especially during the 70s, 80s, 90s, etc.
Thank you. So let's go into risks and liabilities. I guess at the risk of asking an obvious question, for an investor or a developer looking at a site with the perceived presence of some of these contaminants or the known presence of some of these, what sort of risks and liabilities does an investor or developer take on? Why not proceed maybe asking for forgiveness later on? Is it better to not know? Why go through all this trouble of environmental research and potential cleanup?
So, also a great question, because one of the big differences in environmental law compared to many other laws is that even though the primary premise is polluter pays, right? So the idea is at the end of the day, the externalities, if you will, generated by manufacturing, are to be borne primarily by the manufacturer. But the problem with that is that it often never gets to that point, partly because of timing, partly because unavailability of those who might have caused contamination due to proof problems and a variety of other things. And essentially, because of Love Canal, which was a very serious problem from the 1950s, CERCLA was created. And CERCLA is another word for the Superfund laws. And that came about in 1980, predominantly as a result of Love Canal. But it started off in Congress as a tax. Congress realized there were all these sites spread around the country, former military uses as well, I would throw into the mix, and that they were going to cost a lot to clean up. So they went about trying to impose a tax. The tax was, of course, politically unpopular, so they sort of did the next best thing. They said, here's a law that puts the onus on the property owner. So it's what's called a status-based liability. You could be completely non-negligent. You didn't do anything wrong, and yet you are tagged with the cost of the cleanup. And that's why I say it's very close to a tax. Sometimes people call it the chain of title liability. That's not quite right for nuance for reasons we could get into, but it is clear that a current owner would bear liability under CERCLA both at the federal level and at the state level, just by virtue of being the owner. So that's the problem, is who gets left holding the bag in these circumstances? It's the commercial property owner. They can go proceed against others to recover costs, but our California agencies have gotten so used to just going straight to the owner and ironically not even looking further at who the contaminator might be and proceeding directly against them. But they figure the buck stops literally with the property owner, so they let others do the heavy lifting to go against contaminators if they're still around and financially viable.
Okay, makes a lot of sense. The phrase you used, polluter pays, struck me as interesting because someone could inherit a problem, and whether or not they know about it, they could be liable for it. So if a developer sees a great site and they want to develop some multifamily or whatever on this particular site, and maybe they pay cash and don't do the proper due diligence on the site, what you're saying is basically whoever owns it is ultimately responsible. So if the original polluter, hasn't taken responsibility and done the cleanup necessary, if you're the owner, you are now responsible for that cleanup.
Yeah, that's correct, and we're talking about liability and risk, to get back to your original question, in a variety of different forms. There's the liability for cleanup, right? So an agency, and there are many overlapping jurisdictions with different agencies in California and at the federal level and local level. Any of them could tell you, as a property owner, you are now the party responsible for cleaning up this site. So that's one issue, and you're potentially looking at 7-figure or more cleanups in some instances, even for fairly innocuous sounding things like dry cleaners. So that's one, is the cleanup cost. Then you can have exposure to third parties, and that is usually in the form of toxic torts. So things like exposure to individuals or damage to property that can be brought, under common law claims like nuisance, trespass, negligence. There's also exposure as a property owner to those. And there's a particular focus these days in California in the regulatory environment on something called vapor intrusion. The agencies are very concerned about what they used to focus on is contamination that goes down and affects our state water resources, which is an important goal to keep those clean for obvious reasons. But now they're very focused on what might be percolating up at a given site. So there may be residual contamination there, even after a cleanup, even after the state agency blessed it a couple of decades ago. They're reverting to those cases and saying there's a risk that the residual contamination present may not be affecting groundwater, but it might be percolating up and getting through foundations of buildings, and it's getting into people's breathing zones. So there's a lot of focus on that and what that means these days. And I think there's also an overlay, and we can get back into this topic more later on, talking about some case studies, but there's an overlay of environmental justice, and agencies are very concerned about whether any of that contamination at a given site has been pushed out into surrounding communities, especially disadvantaged communities. And are they being affected? Are the vapors getting into people's homes, for example? And so more and more there's a focus on not just what kind of cleanup might be necessary for the property at issue, but also how it might fit into the context of the larger community around it.
Yeah, Preston, there are so many layers to this. If a developer or an investor is looking at a site and they don't know the environmental history of this site, let's say, maybe it is zoned industrial, but they're looking at it for a potential project, either redevelopment, ground up development, or just as a purchase. Are there any red flags or any sort of quick and dirty, so to speak, due diligence that a buyer can do on a site before going down the rabbit hole of phase 1, phase 2, environmental attorneys, and all that stuff?
Yeah. So according to the EPA, there are still about 450,000 of these brownfield sites in the country. And California has probably its lion's share of those properties. So there's a lot of them. I mean, the first red flag, if you will, is just if you're looking to buy and develop properties in urban cores. Urban infill properties, which make a lot of sense for redevelopment purposes for almost every other reason. Transportation-oriented development, walkability, having neighborhoods with mixed use in them and retail. Those are all very desirable goals. And many of our home builder clients, for example, that's exactly the area they want to buy and develop in. The one problem is those urban cores are also the places where industry occurred over the years. And that industry often has resulted in contamination. So I would say, for some of our clients for whom we do kind of the routine, every deal, we're involved in the due diligence, and some are quick in and out because the property is clean, and others are more involved because the properties have some challenges. I would say these days, at least 50% of them come back with some challenges. It's really rare to get a so-called clean phase 1 report these days. Now, if you're looking in, outlying areas that have had very scant history of development, maybe that's different. In agricultural areas, you can get, of course, pesticides and herbicides and other types of chemicals like that. But in the urban core, you're looking at petroleum and solvents and maybe heavy metals and other contaminants that will need to be addressed during due diligence, typically in some way, shape, or form, and at least there's some allocation of responsibility as between a buyer and seller, and maybe other parties that could be involved.
That's really interesting. And so, kind of the pattern that I heard you say is urban infill locations, because those are the places where throughout history uh, there's been a lot of industry and development over the years. And so I think it would be helpful if we could maybe go through an example of a project that you've been involved with. I know you've been involved with a project in Lynwood, California.
Right.
That sounds like it's really had some hair on it. So I'd love for you to just give us some details on what exactly has been involved in that project in Lynwood.
Sure. Yeah, there's been a couple of projects in the city of Lynwood that kind of have drawn me in deeper. It's an area that's very interesting because it has a significant disadvantaged community. It is on all of the socioeconomic scales that the state keeps. They're usually on the very low end of the scale. And there's been a lot of industry there, and maybe those two things correspond, over the years. And so I worked for a private developer on one project, which led to one of the cases that kind of became a seminal case on all appropriate inquiries that we can talk about after this. But for the last 15 years, I've represented the city of Lynwood itself directly. And they have struggled with the termination of the redevelopment agency funding that happened at the state level a number of years ago. And that was really unfortunate for a community like theirs because they lack the funds to get involved in cleaning up and redeveloping these sites. So what they sought to do was really enter into a public-private partnership with the developer for the type of development that they really needed. And in this area of Lynwood, it's actually a certified food desert, which was a term I didn't know before commencing this project, but it's actually a USDA tracking at the federal level, and they've certified this area of Lynwood to be a food desert, meaning residents don't have access to fresh food, like at all, for miles and miles. So the city partnered with a very patient developer, which is the Northgate Gonzalez Markets, which is a great purveyor of fresh foods. And they were interested in this particular site, but the site was very well located for transportation purposes. People can get off a rail site and a bus site right across the street and walk to what will become a Northgate Gonzalez Market. And there's some other retail servicing it there as well. And so the community is ecstatic about the prospect of this very quality grocery store going into to its neighborhood. What it took to get there was so far 15 years worth of federal litigation. We, on behalf of the city, sued the responsible parties. It was originally a series of dry cleaners and a series of gas stations that had produced a subsurface kind of toxic mess that looks like to fully clean it up is like a $10 million price tag, just to give you an idea. So not something that the citizens of Lynwood, wanted to foot the bill for. And so with the disappearance of the redevelopment funds from the state, it meant finding other sources to clean it up. So we amassed a pretty good pool through the litigation and settlement with the responsible parties that the city set aside. And then there was contribution from the developer as well, but that still wasn't enough. And so, fortunately, something occurred that hasn't happened for decades, which is that the state, through the Department of Toxic Substances Control, established a new fund a couple of years ago called the ECRG, or Equitable Communities Revitalization Grants. And this made available, I think it's up to $400 million. That really was a novelty. It's only available to municipalities and not-for-profits. It's not available directly to the private sector. But it meant that the city could apply for these funds, and if they qualified, they could be used to clean up the site that will be, the future home of this grocery store. You got to render the site safe. You can't just go ahead and build this. They're going to be getting their hands in the muck literally as they grade the site. So you've got to clean up a large portion of it first, and then you've got to have appropriate vapor controls to make sure nothing's getting in that grocery store from the subsurface. And then you've got to deal with the liability aspect of it. And because the site is the source of the contamination, and it spreads, in not a short distance, let's put it that way. Potentially the owner of that site is responsible for everywhere where that contamination has ended up, and it goes into the community. So they needed assistance. They also needed some liability relief to make sure that they were taking on the cleanup of this one site with some of their own money, with some of the state money, but also not biting off more than they could chew. If someone had told them at the beginning, listen, you're responsible for cleaning up an entire neighborhood if you buy this site and do us the good service of putting a highly sought-after grocery store here, they wouldn't have done it. So there's another tool used called a CLARA agreement, which is the California Land Reuse and Revitalization Act. And these CLARA agreements are a way to essentially have a squaring of responsibilities vis-a-vis the state, saying we will take on this risk, but we won't take on that risk. And it's a statute, so it's pretty well spelled out in the statute how it's supposed to work. And so the developer, Northgate Gonzalez, was able to enter into a CLARA agreement, in this case with the Regional Water Quality Control Board, to be able to get that done. And otherwise, I would say that deal wasn't going forward. If they couldn't somehow say, here's our contribution, but no more, and city, here's your contribution financially and to assist with these grants from the state, it wouldn't have been able to get cobbled together, I don't think. So we're really glad and fortunate now. The site is entitled. It's moving forward. I'm assured there will be some really delicious tacos waiting for me when the store opens. So we're very excited about that. So that, to me, is an example of how, with enough patience and with the ability to apply for and receive one of these state grants, which again are intended for rebalancing communities that have been sort of deprived of positive development over the years. So it's intended to give a boost to certain communities to help revitalize their neighborhood. So there's sort of a cleanup component to it, but there's a definite emphasis on the revitalization of needed, affordable housing is another example that these grants can be used for. But the grocery store sort of fit right in as to something that was badly needed and desired by the community.
There's so much to unpack there. I mean, with all that you had to go through, it's no wonder that it took 15 years to get to this point. there's on the one hand, people can get so caught up and frustrated in the bureaucracy of everything, particularly this project. But on the other hand, this is a really serious situation, wanting to bring a grocery store in, but having some really serious contaminants. One, I have a lot of questions about it, but one part that struck me was we talked earlier about the idea of the polluter pays. And you were able to go back to the dry cleaners and gas stations who were partially or fully responsible for the contaminants and actually get some sort of settlement from them. Is that typical? Did that outcome surprise you at all?
Also, a really good question. You're good at this, Jonathan. Yeah, I would say there were some tools available to the city that aren't available to everybody, but they were able to utilize here. So one of them is a law called the Polanco Act, and it's essentially now been superseded by another law called the Gatto Act, named after Mike Gatto, who was the lead legislative member in charge of seeing that through. And so he sponsored that bill because cities, municipalities, and other housing authorities and counties sort of lacked the authority to encourage redevelopment, and especially with the disappearance of the redevelopment funds, what tools does a city really have when they are identifying underutilized properties? They may have sat there for decades, and they're either polluted or nobody knows if they're polluted or not. Maybe they're just vacant parking lots. Maybe they have seasonal uses only. But cities can be really good at looking at their areas and their project areas within their city limits and saying, you know what, this would be a great area for new housing, or this would be a great area for an indoor-outdoor mall, or something of that nature. But they need to have tools to assemble those parcels, and they need to figure out if they're contaminated or not. And even if they have a developer in tow who would be interested in the property maybe after it's cleaned up, there's so much legwork and cost and due diligence that needs to go into it in the first instance that the municipalities kind of get stuck with. So along comes the Gatto Act on the heels of the Polanco Act that basically says the city can send a letter to the property owner and say, prepare a phase one environmental site assessment for me. And when that's done, if it has recommendations for phase two, conduct the phase two. And if the phase two says a cleanup is needed here, guess what? The city can enforce a cleanup there. It's still going to be overseen by one of the state agencies that typically would oversee a cleanup. So they're involved in the process, but the city gets to drive it forward. So that's exactly what happened. And if there's recalcitrance on the part of the property owner or the other responsible parties, the actual polluters, they can go to court and get it enforced. So that's exactly what happened. It was a combination of using CERCLA, which is why we were in federal court for that, and the Polanco Act at that time, pre-Gatto Act, that got everyone to the table. And the CLARA law that I mentioned a minute ago, which is a state law, might be the best law on the books for proceeding against polluters. And it is, so for example, one of my partners, shout out to Robert Doty in our San Francisco office, used it very successfully for the Bay Street development in Emeryville in Northern California, going after the polluter of that site. Because, for one thing, CLARA gives you attorney's fees. So the plaintiff gets attorney's fees, which you don't get under CERCLA. So there's always this risk under CERCLA of, how much money is it going to cost me to be able to mount a claim, even if I know I'm right, and even if I know that the defendant is wrong, and at the end of the day will lose, if I can't recover my attorney's fees from the defendant, that's potentially a problem. Clara solves that problem by saying you do get the attorney's fee. So a defendant, if they're likely to be liable at the end of the day, and if they're rational, is looking at having to maybe pay for two sets of lawyers, their own and the plaintiff. So why would you do that? Why would you not settle and just pay for the cleanup if that's going to be a cheaper way to go? So I think that law has been great for spurring some of these cleanups because of that sword that the Clara statute offers.
Okay. That makes a lot of sense, and I think this is a really interesting and important project because of how you talked about the importance of having fresh food in this community, and it gets into the idea of cyclical poverty, and when people live in certain situations, they don't have access to fresh foods. It breeds unhealthiness and more poverty. And so hopefully getting this project off the ground and built, and getting this community and the residents their access to fresh foods, will have a beneficial impact on them for the long term and hopefully for generations. I'm just curious, I don't know if you know the answer to this, but tactically, what's involved in the cleanup? Is it removing several feet of dirt from the site and backfilling it with more dirt, or do you happen to know what's involved in the cleanup?
Yeah. So at the Lynwood site in particular, it is going to be a combination of different methods. You have to realize this site had, on the groundwater table, we haven't really talked about the difference between the vadose zone of soil and the saturated zone, and then the groundwater. But the groundwater table had what's called free product on it. And at one point in time, which means it went essentially straight from the bottom of these tanks at the gas station into the groundwater. So you had free product sitting there, meaning like almost pure form gasoline. And so imagine the groundwater with like 10 feet of pure product sitting on top of the groundwater table, 10 feet, and it extended for a way. So the first thing you have to do is siphon off that pure product, that free product sitting on top of the groundwater table, because you can't get to the dissolved phase stuff, the stuff that's flowing in the groundwater, until you get that big clump of stuff out of the way first. So they siphon that off, and in some cases it remains pure enough that they can almost sell it for reprocessing as product, put it in your car and drive away. And once that was done, and in most places now that was accomplished, but it took years. It's called skimming. You're basically skimming the surface to get that stuff out. And then you can attack the groundwater, where a lot of the contaminant is now bound up and where it's flowing away from the site. So if you have you figure out the direction of flow of the groundwater, and then you can put these like absorbent pads into the groundwater once you know the direction it's going, to kind of block it. So it absorbs the contaminant and prevents it from further migrating downstream. And so that's another tool in the arsenal. And then there's something that's become very commonplace called soil vapor extraction. And despite its name, it's really cleaning up the soil, but it's doing it by using sort of a below ground vacuum cleaner to suck up all of the particles in air in the pore space that adhere to soil. And so when they pull those out, they're pulling out the contaminant, and it has the effect of cleaning up the soil. And then for the groundwater, they'll eventually do injections to the groundwater of called a substrate that will get into the groundwater, and wherever it makes contact with the contaminant, it actually absorbs it and goes through a biological process to essentially dispose of it. So not a lot of, we've tried these days with cleanups to green up the cleanups, right? To not just be picking up contaminants in one property and bringing them to another property, a landfill. That is, in a lot of ways, really inefficient. It's not really cleaning things up. It involves a lot of truck transportation, with diesel fumes along the way. Again, often impacting lower socioeconomic communities along the way. So the more cleanup that can be done in situ, as it's called, on site, it's preferable. And again, trying to minimize the use of electricity to get it done. So those are typically the way cleanups are done. A little bit of excavation, more soil vapor extraction, and injection to groundwater of a substrate to clean it up.
Well, I'm glad I asked, and thank you for going through so much detail, because here I was thinking they were just going to bring in a bunch of excavators and dump trucks and just replace bad soil with good soil. But everything that you explained makes a ton of sense. You had mentioned two retailers that were primarily responsible, dry cleaner and gas stations. As a general investing rule for myself, if I have any indication that there is currently or has been in the past a dry cleaner or a gas station, I just stay away from that property because I don't want to deal with the environmental concerns that we've been talking about for the last 40 minutes. Do you think, is that good advice, or how do you advise people in regards to purchasing a property that is or has been a gas station or a dry cleaner?
Jonathan, I think you're missing out on all the fun sites. From my perspective, there's no such thing as a site that can't be developed with sufficient time and money, right? So everything's doable, and really everything should be doable. And the interesting thing is, who's doing the cleanups out there? It's by and large developers. I love my municipal clients as well, and they're guiding and pushing for a lot of it. But the developers, because they see some value in the real estate, are really the ones that are undertaking a lot of risk, agreeing to be voluntarily under the thumb of government while they do it, which should not be understated, because that's getting scarier and scarier for a lot of them for a variety of reasons that I could go into. And then they are conducting these cleanups and getting them done. And so really, to answer your question, it's the risk reward, right? If you have a perfectly pristine property next door that has all the other same features and is the same price, and renders the same development, then by and large, people are going to go for that, understandably. But if there's a discounted purchase price that really recognizes and gives a developer almost a premium for taking on that risk, then in some instances, it might be worth it. And what I sort of love that challenge of the initial discussion with a client about a new site or a new client altogether, where they're coming to me saying exactly what you're saying. I'm looking at this site. Should I run scared, or is there a reason to go forward here? What are the red flags? And with a little bit of sleuthing, you can figure out a lot. There are state databases that if it's a known contaminated site, it should be on one of those databases maintained by the Water Board or DTSC, the Department of Toxic Substances Control. But beyond that, the whole trade-off is, how much money do I need to spend to determine how bad the problem is, what my potential liability might be as an owner, what my potential liability might be when I'm actually moving the dirt around, and can I get something like an insurance product that might help with my downside risk? And do I have the time, energy, and money to figure this out? Or is it just going to be a headache the whole way through? And, there are properties out there that, to my mind, are worth going through the mental damage because at the end of the day, they are sites that could yield some really good higher and better use of that property that everybody will be proud of and the community will love. And so, and now you've taken, like in the case of the Lynwood property, it's been an eyesore for decades. It's just sat there vacant, um, and it is completely underutilized. And now it'll spur other vibrant development all around it because it will bring a community together and they'll have a place finally to get groceries. So I think, there are a lot of sites that might not be worth the effort if a seller is insisting on too high a price or a price that doesn't reflect that risk. But in a lot of cases, it's just a question of rolling up your sleeves, finding out what's there, and then seeing what risk mitigation measures might be available to that developer willing to go forward. And my friends at DTSC, I'm always telling them, look, when you get a volunteer coming to you saying, I'm gonna submit to your process. I'm going to pay you oversight fees for you to review these documents and approve them and comment on them. Those people should be treated like the folks who go to the beach in Santa Monica on Earth Day and volunteer to clean it up with the little spikes. They should be welcomed into the process and thanked for doing it. That's often not how they feel when they're going through the process, but that's my idea for how folks like that should be treated, because they are doing, at the end of the day, a public service. Are they in it for the profit? Sure, but along the way, there are other folks cleaning up these sites.
Well, Preston, I can tell that we have just barely scratched the surface on all the things that we could talk about.
We've got a couple more hours, right?
Sorry, say that again.
We've got a couple more hours, right?
I want to be mindful of your time. I love talking about this stuff. I think it's really interesting. There's so much to learn, and clearly you've got over 30 years of experience doing this. You've got a wealth of knowledge, and I have no doubt that you are a huge asset to your clients. As we wrap up here, are there any other final key points that you want to leave listeners with?
I think going forward, I do think that something we touched on earlier is going to be increasingly important, and that is the environmental justice component. And I think being mindful of what a surrounding community would really support in the way of redevelopment is really important. And I think it'll go a long way in working with the environmental agencies, because they want to further those goals too. And we always used to say that the environmental agencies weren't in the business of land use, that they just oversaw cleanups. But the reality these days is they are also directly and indirectly guiding land use decision making too. So everyone wants to see these good projects come to fruition. So that's one of the things I think you try to check out early and often is how this particular site fits into its surrounding community. And then I think, talk to an advisor about the tools that are available. Don't despair. I did touch on environmental insurance. I think that's a great tool and a great resource. I think having the right environmental consultant that you can talk to and get advice from, I think, is also very important. So it's having a good team around you. And I would just finally would stress, get them involved early. Don't try to take this on yourself. It is an area with, a deep history in law and a lot of nuances to it that are confusing. And it's at the federal, state, and local level, so you need some guidance typically. And the earlier folks are involved in that, I think, the better the product and the more efficient the approach can be early on.
Preston, I've really enjoyed this conversation, really enjoyed going deep on that example in Lynwood, If listeners hear this and they want to reach out to you, talk to you about your services, or learn more from you, where would you like to send listeners?
Oh, sure. So my email is pbrooks, PBROOKS, at coxcastle, COXCASTLE.com. We also have, our bios for all of the attorneys there at coxcastle.com. So feel free to look us up and see what our experience is. I do think we are the preeminent law firm in the state of California for real estate matters, everything that touches on real estate. And so, I'm happy to be there and be at that intersection of environmental and real estate law. So thank you for having me on, Jonathan. I appreciate it.
Yeah, and Preston, we didn't even get to touch on everything on my outline. You had mentioned environmental insurance. That's a concept that I am not familiar with, and so I'd love to have you back sometime so we can go deeper on some of these concepts. Thank you so much for joining me today, Preston.
My pleasure, Jonathan. Thanks again for having me on.
Listeners, if you enjoyed this conversation, feel free to reach out to either one of us. We love talking about commercial real estate and environmental concerns as it relates to commercial real estate. Thank you so much for listening. Until next time, take care.
Bye now.